We're live.
Good afternoon. It's March the 30th, 2021. This is the House Judiciary Committee, and we're going to hear several bills, including 3 departmental bills and then 4 bills from senators who are going to wander their way electronically across the street. Hopefully they won't get lost. Three bills from the administration. We're going to start with Senate Bill 118. We're going to let them in one at a time. Gary McElhenney should be here. There he is. Mr. McElhenney, if you would, is Mr. Repkowski going to talk too? I guess that's all right. All right, that's fine then. We'll hear from, I know Mr. Repkowski and from other bills from ECM, and he was pretty good on those. So that's good. Let's go. Mr. McElhenney, let's go right ahead.
Good morning, Chair Clippinger and Vice Chair Atterbury and members of the House Judiciary Committee. My name is Gary McElhenney, and I am the Assistant Secretary of the Department of Public Safety and Correctional Services. I am here today to provide testimony on the department's bill, Senate Bill 118, Warrant Apprehension Unit Transfer. Transferring the Warrant Apprehension Unit to the department's Intelligence and Investigation Division makes operational sense for the department's current and preferred reporting structure. The Warrant Apprehension Unit was statutorily established in June of 2011, allowing its employees to be reclassified as law enforcement officers with the powers and protections of the same. The unit executes warrants to retake offenders and to arrest persons who violate the conditions of probation and parole. The unit also obtains and executes search warrants. Senate Bill 118 proposes to codify a transfer that was effected within the department in 2015. Statutorily, the unit reports to the Division of Parole and Probation, while operationally supporting IID as its mission more aligns with IID. The department currently employs approximately 66 sworn law enforcement officers, 39 directly in IID, and 27 under the Warrant Apprehension Unit. Operationally, it benefits the department and the unit for its members to be supervised by a chain of command that includes sworn senior level management. Additionally, the unit's role has expanded to serve both the Division of Corrections and the Human Resources Services Division. Specifically, members of the unit assist with apprehending individuals who walk off or abscond from the department's home detention program. They also serve indictments, provide warrant service during special operations, and serve termination papers from certain departmental employees after separation from the agency. The unit's officers are also assigned to various state, federal, and local warrant task forces and assist in the handling of interstate extradition for parole violators. As you are aware, the past year has presented significant challenges. We commend all of our staff for the work they have done and the efforts they make on a daily basis. We are truly proud of the hard and tireless work of the women and men of this department for their dedication to keeping our community safe. Senate Bill 118 passed out of the Senate Judicial Proceedings Committee and the full Senate with a unanimous vote. The Department of Public Safety and Correctional Services urges a favorable committee report on Senate Bill 118. With that, we are available to answer your questions. Thank you.
All right, I hadn't anticipated anyone else making remarks, but does anyone else wish to, we'll just see if there are questions from the committee for starters and go from there unless there was somebody who needed to make remarks, and I don't see that. So are there any questions on the bill, Senate Bill 118? All right, seeing none, we thank you very much. And that concludes the testimony for Senate Bill 118. Let's go now to Senate Bill 86. And now I know why Jim Repkowski is here. All right. And Danielle Cox also going to testify. So we'll hear from the representatives of the administration from the Department of Labor. They'll each get 3 minutes to talk about Senate Bill 86. And Mr. Repkowski, if you'd like to go first, go right ahead.
Thank you, Mr. Chairman. Mr. Chairman, Madam Vice Chair, distinguished members of the House Judiciary Committee, for the record, I'm Jim Repkowski, Assistant Secretary of Labor with the Division of Workforce Development and Adult Learning, which includes the state's academic, occupational, and transitional education programs in the state's correctional facilities. I bring greetings from Labor Secretary Tiffany Robinson, who has asked me to present Senate Bill 86 to you this afternoon. With me, I have Ms. Danielle Cox, Director of the Office of Correctional Education at Maryland Labor, who will be available for questions after my testimony. Senate Bill 89 is a reintroduction of Senate Bill 70 from the 2020 session. The bill passed the full Senate unanimously this year and last year. However, this is the first opportunity for a House hearing on the proposed legislation. Senate Bill 89 increases the number of mandatory calendar days an incarcerated individual who does not have a high school diploma or equivalent from 120 calendar days to 240 calendar days, or the achievement of a Maryland high school diploma, whichever comes first. State law requires any adult inmate over the age of 21 without a high school diploma to attend at least 120 calendar days of school. The Department of Public Safety and Corrections case managers assign the individuals to school, and they have no choice. Inmates under 21 are required to stay in school until they have achieved a high school diploma, or they reach the age of 21, and at that time, if they choose, they can drop out. Most inmate students are unable to achieve a Maryland high school diploma, which is passing the 4 modules of the GED test, but most do achieve academic gains in 240 or more days. It is important to note that we do not kick any student out after 120 days. As long as they are making academic progress and following the rules, they can stay in school as long as they need to achieve a high school diploma. However, inmates do know the rules, particularly our younger adult inmates. They know that the law says 120 days, and then they can refuse to attend school. And in most cases, they would drop out a second time in their life. If that same student were in a federal correctional facility in Maryland or in 24 other states, they would be compelled to attend school for at least 240 calendar days. A student's completion of a Maryland high school diploma opens up so many opportunities for training and work experience behind the fence. Maryland Labor offers 25 occupational training programs with industry-recognized credentials behind the fence, but a high school diploma is required to access these programs. Similarly, Maryland Correctional Enterprises has jobs and training, most of which also require a high school diploma for entry. And talk about a barrier to employment for returning citizens. The lack of a high school diploma is a huge barrier that we must do everything we can to eliminate when we have the time and access to these future returning citizens. The department respectfully asks for a favorable report on Senate Bill 86. The department has submitted written testimony, as has our partner, Department of Public Safety and Corrections, in support of this legislation. And Director Cox and I are happy to take any questions the committee may have. Thank you.
All right. Thank you very much. We'll go to questions because it's my understanding you were going to talk, and that's fine. We'll do that. Ms. Cox, Director Cox is here for questions. We'll go to Delegate Cardin to begin.
Thank you, Mr. Chairman. Thank you, Mr. Repkowski, for being here. One of my former colleagues from Ways and Means, who was actually one of the few people who was younger than me when we started together. So if and I'm not sure who this goes to, but if a student is doing something other than school that's been approved, whether it be work or has appointments with physicians or other kind of stuff, is there going to be a waiver program that if he can't manage to get the 240 days, or she?
I will comment, not a waiver program. In other words, state law says they have to come into school if they don't have a diploma for 120 days.
Right.
We're doubling that to 240 because we found that we can get more academic progress.
Let's say that a student is going to school 120 days, but he's got to go to see a psychiatrist or something 120 days, and there's no way he can make the additional 120 days, is there some kind of way that he can, that it can be adjusted for that person?
The answer is yes, they're calendar days, but we count days that they come to class. A lot of things happen in an institution to where the educational wing may be shut down due to things going on. There may be a pandemic where folks can't come to class. So we're talking, they need to come to school 120 days. And if I have gotten that wrong, I will hopefully ask Director Cox to gently correct me if I am mistaken.
Good afternoon. They do get released for medical. So if it is a day where they have a medical appointment, whether that be for the psychologist or physician, they can be released for that day to go. And then will just, that day will just be made up later at that time. So it's an excused absence.
And there's no work release that would interfere with school?
No, because they are actually, if they are mandatory, we are the work. They actually get paid to come to school.
All right, let's go to Delegate Juanita Fisher, please.
Thank you, Mr. Chair. Thank you for both of you for being here. I just wanted to understand a little deeper. This is sort of like something encouraging and that will extend the amount of days. Is there anything sort of punitive or I guess damaging to the individual who's serving the time if they don't comply? Or can you explain that a little bit? If that makes sense.
It does, and I guess I'll ask Danielle for some commentary. There's nothing punitive. However, as I mentioned in my testimony, access to other occupational transitional programs require a high school diploma, and as with training programs with Maryland Correctional Enterprises. So while there's nothing punitive, the damage that occurs or what is not good for that student is that they don't have other access to prepare them to with programs for their reentry into society. It is punitive if they don't come during the 120 days that state law requires. I won't call it punitive, but they're compelled to attend school. We found that our teachers are very passionate and they can reach these students, but when we reach an individual at a very low level of literacy, 3rd or 5th grade reading and math, 120 days isn't enough time. And our teachers want that extra time to create that spark in that individual for lifetime learning. And we feel if we were like 24 other states or our federal facilities in Western Maryland, that we could compel them to come in. Sometimes they're just stubborn and they want to break the rules, and you can't make me go to school anymore because the law says it's only 120 days. We want another 120 days to reach that individual to bring them to successful return to society, which includes a high school diploma.
And if I may, they could receive a ticket, what's called a ticket, if they don't come to school, it is an administrative action that can be punitive, but we very rarely give those out. And the reason is because typically we will talk to the inmate, bring them down and say, what's wrong? What's going on? Why aren't you coming? What's the root issue here? Because often it could be something going on at home, an issue with a roommate, that we could get them moved, their rooms because somebody's staying up all night, those sort of things. So we try to work with them to find out what is the root cause of them not wanting to come to school, to make it so that they actually do want to come. And like Assistant Secretary Rapkowski says, we are very compassionate and understand that there are things that come up in their lives that we need to, make sure that we are handle.
Thank you.
Thank you.
Thank you very much. Are there further questions? All right. Well, we thank you both for being here today. Oh, wait, Delegate Champ has a question. We'll go with Delegate Champ.
Sorry, I was trying to find my raise
You're
hand. Thank you. I just had a question about those individuals who may have like some specialized learning needs, disability, learning disability, things of that nature. Are those types of supports and resources provided to them if they need that type of specialized instruction?
I'll defer to the professional educator director.
Yes, we actually, by both federal and state law, have to provide special education services for anyone under the age of 21 who has an individual education plan. So when they come into our facilities, if they are under the age of 21, we actually look at that. We work with the Department of Public Safety, whatever their county school was before they actually came to us, to get that IEP and then to make sure that we are providing those services. We have 10 special educators, one at each site that we have special education. And we also have a special education coordinator that coordinates those services. We have psychologists that come in to do psychology, psychological examinations and testing also. So we do make sure, and even past that age 21, we do try to make sure that they are still receiving those services, because we know that just because they reach the age of 21 doesn't mean that by law, yes, we don't have to, but we know that those issues still exist. So we do try to, so even if they're 40 and had an IEP, they're able to produce that and tell us, and we can find it. We are able then to give some of those assistive services.
Okay, thank you. Thank you very much.
Well,
Any further questions? Hearing none, we thank you both very much for being here. That concludes the hearing for Senate Bill 86. We'll go now to Senate Bill 342. And a representative from the Maryland Military Department. So we're looking for Wendy Scott Napier. There you are. And Catherine Kelly, you're both there. Who would like to go first?
I will go first. Chair
3 minutes.
Clippinger.
Thank you.
Yes, thank you for this opportunity. Here to provide support on Senate Bill 342. This bill will allow armory properties that are surplus to the military department to be considered for other state agency use before they are offered for sale to a local government or to the public. The current law provides that the county or municipality where the armory is located has a right of first refusal to purchase the property. Should another state agency express interest in an armory, the state's clearinghouse process would be utilized to allow that state interest to occur before the local government interest in the property. This would represent a cost savings to the state because we would not have to acquire property in areas where these armories are located, and we would not have to pay for appraisals and title work. Final point to make you aware of, there was a drafting error earlier in the bill that was corrected in an amendment with the Senate, and the bill correctly refers now to section 13217A2 of the public safety article, and it references the Department of Planning, where previously the Department of Budget and Management was listed. And just to confirm, the Department of Planning handles the clearinghouse process. So as everyone may be aware, the Senate bill passed unanimously through the state, and we're urging a favorable report today. Thank you.
All right, thank you very much. And now let's go to Catherine Kelly, please.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. For the record, Catherine Kelly, the legislative officer for the Maryland Military Department. It's a pleasure to appear before you today in support of Senate Bill 342. In the Maryland Military Department, our facilities are consistently evaluated on their ability to support our organization's state and federal missions. We also evaluate our ability to sustain the facility from a fiscal perspective. When it's necessary to divest of one of our properties, we rely heavily on the Department of General Services to facilitate the clearinghouse process. This particular bill provides a little bit of a relief from us by hopefully, speeding up the process of divestiture. We respectfully request a favorable report on Senate Bill 342 342, and I'm very happy to answer any questions you may have.
Are there questions? Delegate Cardin to begin.
Thank you very much, Mr. Chair. Just quickly, so this bill will allow for, instead of the county getting the right of first refusal when it goes to surplus, that there can be first, it goes to other state agencies. Is that my understanding?
That is correct.
Okay. Is this going to impede anything that's happening right now with the Pikesville Armory that we have spent the last 7 years negotiating, and finally have the county, the local nonprofit on board, and we're trying to get it moved from the state over to that nonprofit with the county support? And I don't want this to then also of a sudden interfere with 7 years of work that we've put into this.
This should not interfere in any way with Pikesville. There was no other state interest expressed for Pikesville, but we support your efforts and we know it's been a long time coming.
Okay, thank you.
Any other questions? All right, seeing none, we thank you both very much. And that concludes the testimony for Senate Bill 342. Now we have senators who are joining us, coming from the rarefied electronic and virtual air of the Senate to come and visit us here in the House. And now I've frozen. I think I have frozen. I'm not sure.
Mr. Chair, we hear you.
Just froze. Okay, you can hear me? All right.
And
Well,
you don't look frozen.
Okay, that's good. All right, let's do this. Let's see how far we can get here. We'll go to Senator Sidnor, who is here to present on House Bill, or I'm sorry, on Senate Bill 690. He, I believe, is going to be joined by Bill George and Melanie Shapiro. Okay, and so you'll each get 3 minutes. Senator Sidnor, please. Great polygrad that he is.
You see behind me?
I know, I got you.
Good
He's got his
afternoon.
polygrader. He's sucking up everybody.
Absolutely. You do what you got to do to get a bill passed. No, I'm joking. Look, Senate Bill 690 is a bill that this particular committee in the House has heard before. In fact, on 2 occasions, the House has passed this legislation only to be stopped over here in the Senate. So since I've gotten over here in the Senate, I've been able to get it out, get it back over to you all. What this bill is a bill that actually derived from the Body Camera Commission back when it was first formed in 2015 as a way of protecting or balancing police transparency and the rights of those who might find themselves caught on body camera footage. So what this bill does is it creates or it lists a certain number of categories. I believe it's 5 different categories of situations that might come up, and rather than it be discretionary for the custodian to release, we say, look, these types of this type of footage just doesn't need to be released. The second portion of the bill, what it does is it allows for more control by those individuals that may have been caught on body camera footage. So if they were caught in some of these, in the circumstances or videoed in those circumstances, they have the ability to reach out to the custodian and actually get or view the footage. So those circumstances, you're talking about mainly you're victims of a number of different sensitive crimes, victims of domestic violence, sexual crimes, or child or vulnerable adults being abused. We had also included the capturing of or the depiction of our law enforcement officers who may have been killed in the line of duty. And that one was added because of some years ago back, I would say back in the 1980s, I can recall a friend of my family's whose who was killed in the line of duty. And while there was no body camera footage back then, I can remember when reporting on this, how so much reporting really, I think, adversely affected people having to turn on the news and seeing their loved one who was killed in the line of duty. And that was something that was asked by law enforcement at the time. So, I mean, that encapsulate what this bill is about. My witnesses will certainly go in more depth. This bill, back when it was first introduced, was a priority of the Maryland Association of Counties, and they have, you should have their testimony in support of it. We'll be quiet and allow my witnesses from MML and the Maryland Network Against Domestic Violence speak. So thank you very much.
All right, first, bless you, Delegate Erican. Now we'll go to Bill George from MML.
Thank you, Mr. Chair and members of the committee. Bill George with the Maryland Municipal League here today testifying in support of Senate Bill 690. I'm going to talk a little bit about the perspective from the local governments and how the footage from body cameras intersects the Public Information Act and how this bill will really help our records custodians. So obviously there's been quite a bit of discussion about body cameras and their applicability and important aspect of law enforcement. And their real differentiation when it comes to the Public Information Act is where traditional dash cams or those that are security cameras that are on on light posts are out in the public rights of way. Police-worn body cameras enter into private businesses and homes, taking public records and taking private aspects of people's lives and making them public via the Public Information Act, and these being public records. So what this bill does through its set of mandatory denials and disclosures is really sets a framework for our records custodians to handle Public Information Act requests for this footage. You've heard us and our counterparts at MACO talk to you about the costs associated with implementing body cameras in police departments, and it looks as though that's going to be a part of policing going forward, and it's probably a really good thing. One thing is that this bill will really help cut down on some of those costs that we've talked about, not necessarily on the acquisition of the cameras, but on the long-term costs, one of which is redaction and review for Public Information Act requests. This bill and its bright line of disclosures and denials really will help with cut down on the staff and attorney time for those types of reviews. So with that being said, I'm more than happy to answer any questions and ask for your favorable report on this bill.
Melanie Shapiro, please, for 3 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Melanie Shapiro, I'm the Public Policy Director with the Maryland Network Against Domestic Violence. We are the State Domestic Violence Coalition. As has already been indicated, both the House and the Senate have passed different versions of bills that would expand and require the use of body-worn cameras by law enforcement officers. And MNADV, we support these efforts, and we are hopeful that the accountability and transparency created by the expanded use of body-worn cameras by law enforcement can help restore trust and confidence in law enforcement. However, we need to balance the expansion of body-worn camera usage with the needs of victims of domestic violence and sexual assault. It is estimated that approximately half of all domestic violence incidents go unreported. There are a variety of reasons for this. Some of them include a desire for privacy, fear of reprisal, shame, as well as an overwhelming mistrust of the police and fear of not being believed by the police. So we need to ensure that the proper policies exist for the release of body-worn camera footage that captures these incredibly private and vulnerable moments. And that's exactly what SB 690 does. It narrowly limits the release of body camera footage in specific cases, including cases of domestic violence and sexual assault. The footage is still available through the evidentiary process and admissibility in civil and criminal proceedings. It does not impact what is a public record that has been entered into evidence in a court proceeding. It does require a victim who is the subject of the body-worn camera footage to be notified of all requests to view it. And it does prevent the copying of the record by a person who is under investigation, charged, subject of a piece of protective order, pled guilty, found guilty in the recording for that incident. And one of the reasons why that is particularly important, I would direct your attention to the testimony submitted, and I know it's submitted on the Senate side by the Women's Law Center, in which there is an individual whose abusive partner obtained body-worn camera footage and subsequently placed it on social media available for anybody to view. This bill is about victim safety, victim privacy. It's trauma-informed and victim-centered. It carefully balances the needs of victims of domestic violence, those of confidentiality and privacy and safety, with the need to develop trust and confidence in the police. It also balances the interest in the constitutional rights for those involved in civil and criminal justice systems. Senate Bill 690 incorporates recommendations from a 2015 commission regarding the implementation and use of body cameras by law enforcement officers that was in Maryland. And it's consistent with policy considerations that were generated from national experts during the International Association of Chiefs of Police in 2017 through a national forum on body-worn cameras and violence against women. The Senate passed this bill unanimously this year and did so without any opposition. And in 2017, it overwhelmingly passed the House. We're asking for a favorable report on SB 690. Thank you.
All right, there are questions, several. I'm going to hear from Delegate Moon first, then Cox, then Grammer. So we'll hear from Delegate Moon to begin.
Thank you, Mr. Chair. Welcome back, Senator Sidnor. These questions might be familiar to you. I remember this bill from past years, and I will just say up front, the domestic violence protection and sort of victim identification provisions in the bill do not concern me. I think those are good parts of the bill, but the bill does a lot more than that. And it's the rest of it that I just want to flag again. And I'll start with the first question, which is, I think we last had this bill in 2017. Did the text change at all? Or is this the same bill that we saw several years ago?
There was one amendment to the bill since it was passed in the House in 2017, and that was an amendment that we added at the request of Maryland chiefs and sheriffs, and that language, that amendment is at the end of the bill, section 3, which says a custodian may not allow copying of a recording from a body-worn digital recording device by an individual who has received probation, a PBJ for, or is subject to a peace order or protective order, so forth.
Got it. Okay, that makes sense to me, actually. So here are the questions I have and where I have some concerns about this bill. And I'll flag two broad issues. One, just so the committee's aware, the bill is about mandatory denial. If a request for this body cam footage comes in, the answer must be a hard, absolute no. You may not see this portion of the footage. In prior years, and as I've talked to Axon and some of the other body cam vendors, they will tell you that it is very easy now through their software to just blur out portions of video and to do it continuously over. They don't have to sit there and do a bunch of manual work. If you say that Senator Sidnor's face, that shouldn't be there, take him out, they can actually just easily blur the rest of Senator Sidnor being in the video. And so in the past years, we've debated this bill. I've tried to tease out where people think the line is when we blur something versus when we say, no, you cannot see this ever at all. And it appears to me that this bill has chosen again to go hard to the you may not see anything here ever, and blurring is not even going to solve our concern. Again, I don't have an issue with that with the victim protection provisions, but here are, I would point you to on the bill, page 5, you will see on lines 22 through 31. This is, to me, the interesting portion of the bill. And what it says is, if there's ever a death of an officer on the job, mandatory, you will never see that footage. And it's not even a redaction. You just can't see the footage. On the floor today, we had extensive debate about the Amy Caprio case where people were discussing the footage. So I just want to question, I guess, whether we think that would have changed how that was handled there and if that's the intent. And second, even more troubling than the specific exclusion on that is that it says there's a mandatory denial of body cam footage if there was not an arrest, a temporary detention, attempted temporary detention, a search and attempted search, a citation at death, or an injury. Well, there's a whole lot of police interactions that don't result in those things that are otherwise profiling, discriminatory, whatever. And I would just point out that this would be a mandatory denial for an entire category of police interactions that has nothing to do with victim privacy, nothing to do even with the death of an officer in that other clause, but it's mandatory denial. It's not blurring. And again, I think you're trying to clean that up by saying, well, if there's a complaint filed, but part of the way I'm going to know if I'm going to file a complaint is if I go back and look at the body cam footage and see if the footage is going to be favorable to what I'm suggesting. So again, that was my position several years ago when we last had the bill. So I'm curious if that's been at all dealt with in this year's version of the bill.
I wondered if we were going to get to it. Isn't that so at the end of that? Having said that, all right,
Nope,
that's fine.
have you all fixed it?
All right, Senator Sidnor.
I'll say thank you for the question. Obviously, with the bill coming before you all, if that's something that you think needs to be addressed, the bill is before you all. But what I will say is that all of those mandatory denials are subject to Section C. So, and in Subject C, if you were one who was depicted in that video, all of those denials are well, the mandatory denials you would not be subject to. You'll have the right to obtain that information and to look at that, obtain it. And this was something back in the day that when I was talking to some of, I guess, groups that might want to just kind of pull in a lot of this information, this puts me in the driver's seat of a situation that happened to me. And if I want to then share it with an advocacy group, I have all rights to do so. But I believe it puts the person who's been caught, me, you, or whomever, caught on video, it puts you in the driver's seat.
All right, we'll go to Delegate Cox, then Delegate Grammer.
Thank you, Mr. Chair, and good to see you, Senator Sidnor.
Hello.
Thanks for the bill. I wanted to commend you on the bill, and in light of Delegate Moon's comments, I was looking carefully myself at Section C, subsection C, and it seems pretty broad, including those who represent a deceased person. So, I mean, it seems to cover all of those concerns, and I didn't see any objection in the record from the members of the press. Is that true?
That is true.
Okay, thank you.
You're welcome.
Delegate Graham.
Thank you, Mr. Chair. Senator, good to see you. I have a question
Hello.
about page 5, line 5. So this would restrict the information if it has been entered into evidence in a court proceeding. Can you tell me, in general, for Public Information Act laws in Maryland, is that a unilateral rule that any document that is entered into evidence as a court proceeding is therein excluded from PIA requests?
You know, I'm not even going to try to guess, but I have Ms. Shapiro, who used to work with the office, and I think she can give if you're looking for a real good answer, I think she can answer that
You're
much.
going to defer to counsel here.
Absolutely.
I was a little worried you were going to do that, Senator.
Sure. All right.
My guess, so the evidentiary process is separate and apart, and the discovery process is separate and apart from the Public Information Act section. So that's really different people outside of the court process trying to obtain information. There's rules of discovery, rules of evidence. And in the adult court system, at least, obviously the rules are different for the juvenile court system, but those are open and public proceedings. And so I would imagine that any evidence that is admitted through that would be available to the public as well.
So am I reading this improperly? Because the way I read it and the way I'm thinking about it is that if one of these recordings is entered into evidence in a court proceeding, the public does not have access to it. Am I thinking about this properly?
Oh, no, yeah, that's incorrect.
It's the opposite, I think.
Once it's entered into evidence, it's public.
Okay. I had that backwards. I appreciate the clarification.
Thank you for your question.
All right. I'm done fighting with my Zoom now, apparently. Further questions for the panel? All right. Seeing none, we thank you very much. And that'll conclude the testimony on Senate Bill 690. Thank you.
Thank you all.
All right. Have a good day. We're going to go now to Senate Bill 752. Senator Hayes, who I think is with us. There he is. Senator Hayes on Senate Bill 752.
Sure. Good afternoon, Mr. Chair, Madam Vice Chair, members of the Judiciary. 752 is Senator Antonio Hayes for the record. 752, you all heard House Bill 1318, which was the cross file, essentially gives the flexibility to Baltimore City Police Department in their promotional standards. There was an amendment to the bill allowing the department choose up to 25% of the original list. The bill is introduced prior to the amendment, reflected an increase from the rule of 5 to the rule of 20. Rule of 5 essentially meant that the 5 highest persons that scored on a standardized test was automatically determined as the best qualified for the position. We originally had proposed to change that to 20. There was some amendments based off of discussion and delegation to change that to 25% of those who applied. And so with that, Mr. Chairman, members of the committee, I urge for a favorable report on Senate Bill 752.
All right. Are there questions for Senator Hayes?
Of course not. No.
Seeing none, we thank you very much.
Thank you. Have a good day.
No problem. The testimony for Senate Bill 752. Now we have Senator McCray, I think, maybe not. Okay, Senator McCray will be here shortly. We have Senator Jackson. Senator Jackson is coming in. So we'll go to Senator Jackson here in a moment. There is Senator Jackson. We're going to go to Senator Jackson for Senate Bill 608. He is the sole person to testify. We'll give him 3 minutes. Senator Jackson, go right ahead.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. For the record, Senator Jackson representing District 27 on behalf of Senate Bill 608, commonly known as the Public Safety Article. Senate Bill 608 is a piece of legislation that makes a few changes to both the work and administrative processes of the Maryland Police Training and Standards Commission. As we all know, the Maryland Police Training and Standards Commission sets the basic practices for police training throughout the state and in one way or another touches each of the communities that we represent through this work. And as a matter of point, Mr. Chair, your committee passed this bill out 22-0 last year, and COVID ran out on the Senate side. Made up of 24 members, the governor appoints 8 members to 3-year terms. 2 senators are appointed by the Senate president, 2 delegates by the House Speaker, with 12 members serving ex officio. There are 2 primary administrative changes that the bill makes to the commission. The bill would make the Secretary of the State Police the permanent chair of the commission, as opposed to having the commission members elect the chair. The bill would also allow non-gubernatorial appointed members to designate representatives to attend meetings and perform committee functions on their behalf. The legislation would also make some changes to training requirements for new and current officers. These training requirements include enhancing entry-level and in-service training requirements to supplement training in criminal law related to rape and sexual assault, human trafficking, and evidentiary procedures. Additionally, new training programs will now be required in the area of de-escalation in the use of force, the prevention of profiling, and the recognition and prevention of discrimination based on race, color, religion, or creed, national origin or ancestry, sex, sexual orientation, gender identity, age, physical or mental disability, marital status, veteran status, genetic information, and citizenship status. The Maryland Police Training and Standards Commission will also now be required to conduct job task analysis for entry-level police officers every 10 years. As you may also know, my background in law enforcement leads me to understand how vital training is for the men and women that are charged with such a duty. With that, Mr. Chairman, I would ask you and your committee for a favorable report of this legislation. I'd be happy to answer any questions you or the panel may have. Thank you.
Are there any questions for Senator Jackson? Seeing none, we thank you very much. That concludes the testimony on Senate Bill 608.
Thank you,
We'll go now
sir.
to Senate Bill 360. You bet. There is Senator McCray. Senator McCray to testify on Senate Bill 364. Go ahead, Senator McCray.
Thank you, Mr. Chair. Thank you, Madam Vice Chair and members of the committee. For the record, Corey McCray, Senator for the 45th Legislative District, East and Northeast Baltimore City. I come to you on behalf of Senate Bill 364. What 364 is a bill that I introduced last year, and now it's come out of the Senate, come out unanimously. It basically, Baltimore City, as you know, Mr. Chair, a couple years ago, passed a rule where anyone that was sued the police department, sued the city of Baltimore, that they will still be able to speak their truth. We have a number of police departments inside of our city. That's Coppin, Morgan, some that's ready to be formed. Currently, the state ones already have non-disparagement agreements. So you cannot, you can sue, but you cannot be held to some type of disclosure to say that you wouldn't be able to comment on the incident. Because of the precedent that this was set in reference to our city council, our mayor at the time, pushing forward, we thought that it was to make sure that all police departments that operate in the city of Baltimore followed the same logic. This bill was brought before the delegation. It was passed unanimously by both the House delegation and the Senate delegation, and I just ask for a favorable report.
Are there any questions for Senator McCray? All right, seeing none, we thank you very much for your testimony today on Senate Bill 364. Thank you very much.
You all have a blessed day.
That concludes, all right, that concludes the testimony for 364, Senate Bill 364. That concludes the testimony on the bills before us today. There's a possibility that we will have a voting session after the second session tonight. At this point, we're waiting a little bit. There are a couple balls up in the air at the moment, but I would expect a voting session perhaps either tonight or tomorrow. We'll announce it one way or the other at the second session here this evening, but we will not have a voting session between now and our session, which is at 4 o'clock. All right. Thank you very much. Have a good